Pension interest. What does the divorce order say? Hi, I'm Simon de Penay and I'm a family attorney. This is the second of 3 talks on pension sharing. In the first talk, I looked at divorce and pension interest. This is the stake one spouse has in the other's pension. It's a theoretical amount of the member spouse's pension that the non-member spouse is entitled to on divorce. Now, I outlined the types of funds eligible for pension interest and the role of the matrimonial regime in determining pension interest. In this talk, I'm going to tell you why the wording of the divorce order is so important when it comes to pension interest. There are certain legal requirements the divorce order must meet to enable the fund administrator to action the claim. Any omissions or unclear wording may result in the divorce order being invalid. This could mean the divorcing couple has to apply to the court to have the wording of the divorce order changed. This process is expensive and time-consuming and can be avoided by adhering closely to the requirements. The Divorce Act states that there must be a specific reference to pension interest. If the pension fund is a preservation fund, Section 37 capital D subsection 6 of the Pension Funds Act must be specifically referenced. The fund in which the member spouses invested must be specified by name. It is not sufficient to name the fund administrator, as a pension fund administrator could be responsible for more than one retirement fund. The divorce order must provide clear details regarding how much pension interest is payable to the non-member spouse and how this amount should be calculated. It's best to give a set percentage or rand value of the pension interest to avoid confusion. Furthermore, there must be a specific instruction to the fund to make the deduction and payment to the non-member spouse and to endorse its records accordingly. If the divorce order stipulates that the member must make payment to the non-member spouse, it will be considered defective. A defective divorce order does not mean the non-member spouse can never claim the pension interest. It can be rectified by mutual agreement between the spouses, but they'll need to go back to court for an amended order. Now, from a practical perspective, there is a process to follow. The non-member spouse must provide the retirement fund administrator with a copy of the divorce order. From this point on, there is a strict set of timelines to follow, which I'll cover in the third and final talk in the series. Once it has been determined that the divorce order meets the stringent requirements of the Divorce Act, the non-member spouse can either withdraw the funds in cash or transfer them to another approved retirement fund. They must choose one option or the other. They cannot make a partial withdrawal and invest the balance in a retirement fund. If the pension interest is from a retirement annuity and the non-member spouse wants to transfer to another fund, that fund must be another retirement annuity. Now, this transfer will be tax-free. However, if the non-member spouse chooses to withdraw the funds, the withdrawal will be taxed. If you've got any questions about pension interest, give me a call on the number in the signature below.